Now we're going to turn to insurance. Civil nuclear for maritime basically won't succeed if it can't be insured. And I'm really, really pleased that the leading voices within the insurance sector are working with us and partnering with us in order to think about and shape the future of the market. So I'm going to invite the next group of panelists to come up. So we've got Ian Truman, a partner in the nuclear team at Burgess Salmon. He will be delivering a keynote. He will be joined by other panellists. We've got Mark Popplewell, Managing Director at Nuclear Risk Insurers. We've got Daisy Roche from International Group of P&I Clubs. We've got Kimberly Sexton-Nick. She's the head of the Division of Nuclear Law at the OECD's Nuclear Energy Agency. And of course, we've got Mikhail Bo, who's going to come up again to Corp as CEO. But in this session, he's actually wearing his NEMO hat because he's doing a lot of work with NEMO in order to look at the whole issue of civil liability. So please join me in welcoming our panelists.
Good morning, everyone. So my name's Ian Truman. I'm a partner in the nuclear law team at Burgess Salmon. So I'm not an insurance specialist, but inevitably nuclear liability particularly is a large part of my practice, and I work very closely with nuclear insurance and nuclear insurers for my clients. I'm clearly not a shipping lawyer, so please excuse me if I butcher anything in terms of shipping terminology during this presentation. When I speak to colleagues in the shipping sector, one of the things they say to me is, why can't we just build one of these things? Can't we just get on with it? And so what I'm going to focus on today is what we have to address from the nuclear law side to be able to do that. I'm going to try and set the scene. I'm going to go into a bit of the sort of basics of what nuclear law is, give some background, and really try and set the table here for the panel discussion that's following, and what we need to do from the nuclear side, particularly to enable the deployment of nuclear ships by the early to mid 2030s, which we heard about earlier. The how question from Charlotte inevitably is what we're going to focus on here. It's very easy to sort of talk about challenges, which I think historically we might have been guilty of, but now we're really in a position to talk about how we deliver this. Haven't got all the answers yet, but we've certainly got a direction of travel and a very firm idea as to what we want to do. So I am going to run through the basics of nuclear law, but the main focus today is going to be nuclear liability, that being the special liability regime that is in place to deal with nuclear risk. And that's principally around the compensation of third parties in the event of a nuclear incident. We're then going to look at how that might apply to civilian nuclear ships, and really the role of insurance alongside the nuclear liability regime, and indeed the role of insurance in developing that regime. So I'm going to touch on the fundamental principles, how they apply. We're going to look at some historic precedents of a previous attempt to insure nuclear ships and what we can learn from that going forward, and also some interesting agreements historically around the Otto Hahn and the NS Savannah to facilitate the voyages of those ships. So, looking at nuclear law, if someone says to me, why is nuclear law different? This is typically the model I'll point them to. It's an IAEA model, SSL it's called. Nuclear law in its essence is basically a legal framework for conducting activities relating to nuclear energy and ionizing radiation so that you protect individuals, property, and the environment. And that's the fundamental safety objective of nuclear law. So what makes it different are these three areas. In the I like a Venn diagram you'll see in these slides: nuclear safety, nuclear security, nuclear safeguards, and where those all intersect, we have nuclear liability. We've already heard this morning around certainly safety and safeguards. Security is another crucial aspect. But these are the points that we're going to focus on at a high level before really homing in on liability. There are other areas covered by nuclear law that sort of relate to these: emergency preparedness and response, waste, things like that. Nuclear law appears in several forms. We have treaties, we have conventions under the auspices of the IAEA and the UN. We have United Nations Security Council resolutions and bilateral agreements, both in safeguards with between member states and the IAEA, but also other agreements between states, which is quite important later on in the talk. We'll come back to those. And other instruments also that have become customary international law. Most of these laws, in fact all of these laws, weren't designed specifically with nuclear shipping in mind. Some of them do cover aspects, others specifically exclude them, and we'll come on to what the position is with the liability conventions further down the line. So this Toby sort of hinted earlier at a sort of deployment model for nuclear ships, and this is a very rudimentary sort of conceptual way of looking at it in terms of the different scenarios or the different stages of the process. And we've also heard from Michael about green corridors, and the idea here is very much to form a nuclear shipping corridor between two maritime nuclear states to start with. I think what is clear is whilst we might need a multinational convention in the end under the auspices of, say, the IAEA, if we wait for that, there is no hope of getting nuclear ships off the ground in the early to mid-2030s. So the bilateral arrangement is a way of trying to get the legal framework in place to enable insurability, because that is the way that it typically works. The insurers will need a legal framework to be able to have the certainty they need to provide insurance. There are those triple SL aspects that we had before: safety, security, safeguards. Work on each of those is underway. There are NEMO working groups on all of those aspects. And the IAEA specifically has talked to NEMO and is developing an approach for safeguards for nuclear ships. And where we are on liability, that is what we're really going to focus on today. And what we're going to look at is how the liability regime has developed and why. And then we're going to look at the fundamental principles of it and how they translate into shipping. So right back to the beginning, in terms of why the special reliability regime arose in the first place. We have radiation essentially being discovered at the end of the 19th century in the form of X-rays. For a large part of the first half of the 20th century, use of radiation was pretty minimal, so no one was really concerned about it. We then have a step change at the end of the Second World War, and of course we have the nuclear weapons that were used at the end of the Second World War. In the early 1950s, the insurance sector started to focus a bit more on what radiological risk was, and started to look at exclusions for radioactive contamination from conventional insurance cover. We then have a push for civilian nuclear power in the mid-1950s. An article in The Economist was a good example of that. And that really opened everyone's eyes to the potential for nuclear power. And this was a time when there was a general energy shortage across the world after the Second World War. So we had the insurance associations from the UK and the US. So note, this was led by the insurers to start with. The development of the international nuclear liability regime was actually led by insurers. They were integral to it. They got together and they tried to work out essentially how they could formulate a legal regime that would be insurable, that would balance the needs of industry to incentivize them to stay in the nuclear power sector with the balance of compensating third parties in the event of an accident. We then had domestic legislation in the US and the UK in the late 1950s, and following that, development of international nuclear liability conventions in 1960, 1963, which were then amended over the years. Some important points before we leave this slide. In the period between these early discussions about nuclear liability regime and the international law coming in place, there were nuclear ships operating in the late 1950s. Before these conventions came in place, there were bilateral agreements that were being used as the basis for insurance of nuclear power stations as well. So that's an important precedent, I think, to recognise. If we're looking at what a civilian shipping nuclear liability regime needs to look like, it needs to address, in my view, these fundamental principles, which are common across all the liability conventions that we have today. First principle is absolute liability. So the operator is absolutely liable. That means that there can be no liability on the operator outside the nuclear liability regime. That's quite an important point. We'll come back to that later. Liability is strict and absolute. So the strict liability means the operator is liable regardless of whether it's at fault or not. Exclusive liability means that no one else can be liable for that loss. Called channeling, and it essentially allows all of the insurance capacity to be focused on one party within the supply chain, rather than requiring all the supply chain to insure against nuclear risk. Minimum amounts, so you have to have insurance or you have to have a limit of liability above a certain amount. So for example, in the Paris Convention, it's 700 million euros, and then that's supplemented by another convention, which ultimately takes it up to 1.2 billion. In the UK, that's all provided by the operator, and then there's another layer on top of that from the third tier, the Brussels Supplementary Convention. Limited in time. So typically there are prescription periods for nuclear liability, 30 years for personal injury, 10 years for other types of damage. So this is to ensure that operators don't have an open-ended liability, and again to try and recognise the the insurability of this risk. And even the 30-year liability tail for personal injury can cause difficulties from an insurance perspective. But that is being worked out on the land-based reactor side currently. Mandatory financial coverage. So operators have to have financial security by insurance or other means for the amount of its liability cap under the law. So it has to be there. It's a condition of operating. Channeling of jurisdiction. This is an important one, an interesting one in the context of nuclear ships. What this means is that if someone tries to bring a claim against an operator in the court of another state that is a contracting party to the same convention, that state's court is bound to operate within the nuclear liability regime. And that's very important. So over the years, there's been a great concern about what's called gap risk, where you have a claim being brought in another country which isn't party to the same convention. The claim is outside the confines of the nuclear liability regime. It can be made against any party in the supply chain. Liability could be unlimited. And you can see that in certain jurisdictions, typically America, there has been great concern about the amount of liability that could arise on different members of the supply chain. And certainly after Fukushima, we did see several claims against GE, which provided the reactor to TEPCO along those lines. And then the last one, non-discrimination. I say there's no discrimination based on nationality, domicile or residence in terms of the compensation that's provided. So looking at how the main existing regimes deal with nuclear ships. Paris Convention, straightforward exclusion for reactors comprised in any means of transport. Same sort of thing with Vienna. We have essentially Paris and Vienna are two parallel regimes for different groups of countries. The reason that ships were excluded in this way was because the intention was to develop a third convention covering nuclear ships specifically. And that is the 1962 Brussels Convention, which you may have heard of, which was developed and adopted but never ratified. So that is why we've been left with a gap. That is the gap that we're trying to fill, ultimately with a multilateral convention, but in the meantime, getting us off the ground with a bilateral arrangement between nuclear maritime states. I'm not going to dwell too much on the Brussels Convention. I think that's been done to death in a way, but I will try and pick out some of the issues that we can learn from. Why did it fail? Many reasons. I've picked out a few here. I'm not suggesting this is comprehensive, but at the time it had become clear maybe that nuclear shipping wasn't taking off in quite the way that had been initially envisaged. And obviously that's not the case now. We have a stronger business case for this, as you've heard this morning. At the time, warships were included. And that was quite controversial then, and certainly that wouldn't be the case now. It didn't deal with port entry, which is obviously a key factor, which is going to be dealt with through these bilateral arrangements now. And there was an argument between member states about what rules should apply, whether it was right that you'd have this nuclear liability law, or whether the rules of international public law should apply instead. That argument has since been settled through the widespread adherence to the Paris Convention, the Vienna Convention. So, in short, what to take from this is that some of the landscape has shifted now, and there is a way forward in terms of how we progress the nuclear liability arrangements and the insurance that accompanies that. Treaties take a long time. I think whatever sector you're in, everyone's aware of this. From a nuclear liability perspective, which is the one I know the best, I'll take the Paris Convention. Work started on that in the mid to late 1950s. It's dated 1960, but it didn't come into force until 1968. The recent protocol to the Paris Convention was adopted in 2004, didn't come into force until 2022. I'm sure there are examples on the shipping side as well as to how long some of these things can take if you try and do everything everywhere all at once. And that is really what we're trying to find an alternative to in the meantime, whilst we get a nuclear shipping corridor off the ground. The IMO has announced it's updating, or it's going to update and review the Code of Safety for Nuclear Merchant Ships, which has already been mentioned, which essentially gives the nuclear side of the equation the green light to really get going on its part of this. So the IAEA Atlas program we've heard about this morning already. The NEA is also looking at this, and they're having a conference in December, which Kimberly might be able to say a bit more about. I'm already signed up to that one. And so we really need to now look at identifying the right parties for this initial bilateral agreement. What will that look like? Before I move on from this slide, the last bullet point on the slide here, I think, is an important one. The civilian nuclear liability regime for land-based reactors, yes, there is an insurance layer, but there is a government backstop. And I think we can't get away from the fact that there will probably have to be a government indemnity somewhere to backstop this. If we get a bilateral agreement setting out the framework for nuclear law, that's insurable. Of course, that insurance has a limit. And of course, we have to deal with what happens if a claim exceeds those limits or somehow falls outside those limits. So again, not saying that we've got all the answers at this stage, and we'll certainly look at the precedent for that sort of arrangement. And certainly on the land-based side, the government is the insurer. The government of the state where the nuclear installation is located acts as a insurer of last resort, essentially. So, international agreements. So there are lots of international agreements, clearly. Some of them relate to nuclear law. Some of them relate to maritime law. Some of them relate to nuclear law and maritime law. They cover both. So things like UNCLOS, SOLAS, transport regulations for shipping nuclear materials. What we're looking at here, again, I told you I liked a Venn diagram, that intersection in the middle there, an intergovernmental arrangement that deals with nuclear law and maritime law and provides a legal framework covering those pillars of nuclear law that I mentioned, SSL, that provides the certainty that the insurance sector needs to be able to provide that insurance. And of course, a government that will sign on and provide that ultimate backing. What will it cover? So we've covered, I think I'll just run through this. Mutual recognition is something I think is important, and that is why it would be so helpful to have two established nuclear states to start with. We will need acceptance of a design, accreditation, or a licensing process between two regulators. This is already, the work of harmonization is already happening for small modular reactors. It's not there yet, but work is happening. We're seeing regulators jointly approving designs, which is a great step forward. But ultimately, that is what is going to have to happen. The licensing flag state will license a reactor, and the port state on the other end will have to accept that that is a safe design and accept that license. It might have to do certain checks of its own, but fundamentally it's not going to relicense that nuclear reactor. Emergency planning is the other one. Emergency planning zones are a hot topic. Essentially, in the world of emergency preparedness and response, an operator typically has to make emergency plans for a zone around its installation. And obviously, the bigger that zone, the more difficult it is, the more people could live in it. And you can imagine in a port or when you've got a moving reactor where that zone is moving the whole time, going over new areas of land, it gets very, very difficult, if not impossible, to ensure, under the conventional approach at least, to emergency preparedness and response. And that is why we talk about the risks associated with these new reactor designs being fundamentally less. The credible accident scenarios mean that we can shrink that EPZ down to hopefully within the ship. So looking at lessons from the past, some issues. These are the principles of the Brussels Convention that we've got here. So again, you can see many of the same principles of nuclear liability that I went through initially, which makes sense because this was originally developed alongside the Paris Convention and Vienna Convention. You've got exclusions for acts of war and hostilities, which is a standard exclusion from all of the conventions. You've got the prohibition of operating without a license, which is an interesting one. That's not in the other liability conventions. That is in the more general Convention on Nuclear Safety, which doesn't apply to reactors that are on the water. So you can see there that they're similar to the fundamental principles that we talked about before. You can then look at the agreements that governed nuclear ships or the Savannah and the Otohan. So in those examples, port entry was achieved through a series of bilateral agreements. So that's showing that it's been done before. Dealing with questions like limits of liability, jurisdiction of claims, and setting a limit of liability, which was pretty high. So $500 million US back then, according to Google, is about $5.16 billion today in today's money. So quite high liability limits back then. And 400 million Deutschmarks for Germany with 1.7 billion today, perhaps a bit nearer the 1.5 billion in total under the Paris and Brussels Conventions. So you can see there are these arrangements that have been used before, and I clearly wasn't around when they were being negotiated or to comment how effective they were, but I've not seen any commentary suggesting they caused any particular difficulties. But they did have to be agreed at the state level. So what are we looking at here? We're looking at a bilateral agreement where insurance could provide the first layer. I've put in a number here, but that's purely based on what the typically what the other conventions provide. Mark can comment further about whether he thinks that amount is realistic. Maybe we have a supplementary layer provided by all of the parties to the convention, all the parties to the treaty once we get a certain number, as we do with the Brussels Supplementary Convention, and this need for a backup government indemnity as the insurer of last resort. So what I've got there on the right-hand side of the slide is a picture of one of the publicly available agreements from AUKUS, which is an agreement between the United States, the UK, and Australia around the sharing of know-how to build nuclear submarines. So it's not directly a precedent for what we're looking to do, but it does show, it is an example of a recent bilateral agreement between a smaller number of countries that deal with aspects of nuclear law. And significantly, it has a government indemnity in it. So it's tempting to think that, well, what government is ever going to sign on to giving an indemnity in this scenario? But where there is an interest that they are committed to, I do not think it's out of the question. And it's certainly something that that I think we'll need to get this off the ground. So we think it is politically achievable. But as has been mentioned this morning, there's a big bit of work to do in terms of hearts and minds, particularly around how safe this technology is. And then we need to work out how that indemnity works through the supply chain, which isn't particularly difficult. But that's something we can add into the bilateral agreements that we develop. So what I was trying to do with these questions is to sort of pose some questions for the panel to discuss. I think we have more, but what I hope I've got across is certainly how integral the nuclear insurers are to the nuclear liability world and vice versa. They were the ones that originally developed the regime, and the availability of insurance and the fact that it's mandated for all operators is a really crucial part of that. And that is why this work stream is so important, because without a nuclear liability regime, without insurance, it's very difficult, as we've said already, to see this getting off the ground. So that is me.
Thank you, Ian. That's a fantastic way of showing us, especially us from the shipping sector, how we take this challenge of liability, and we bring it in and marrying it to all the other liabilities that we find in the maritime market. And I was just going to say to everyone here today that I've sat through countless sessions talking about how liability will function for nuclear in the maritime market. And every single time, the frustration that emanates from having an endless discussion about large amorphous blobs of challenges from which questions come off, follow questions without actually any pathway to answers. It's remarkable to sit here today and see for the very first time a logical ordering of how those challenges are queued up behind each other to create what we think is now the light at the end of the tunnel for how these solutions, that we have not found a single showstopper in any of this that we've already able to identify that says you can't do this, right? So now we're, by logically ordering this and saying, look, instead of just talking about what we couldn't do yesterday, we're now able to start talking about what we can do tomorrow. And I think that's an incredibly positive thing for everyone to take away from these sessions as well and say, look, this is one of those areas where it's really hard to imagine how you take these two worlds that don't speak each other's language and you bring them together into something that actually functions. And there's going to be questions that come from this on whether it's a marine market, whether it's a nuclear market, whether it's a combined market, or whether it's a new market. And I think this new market opportunity is potentially the one that we're going to see developing along these bilateral things. And just with that, I'd like to introduce, or rather I'd like the rest of the panel to introduce themselves and provide their perspective on this. And we're going to start at the end with our very good friend Daisy from the IG, and a quick introduction on how you see this, and then we'll move across the panel and then move on to some questions. Daisy.
Thank you, and good morning, everyone. I work for the Secretariat at the International Group of P&I Clubs, and my responsibility there is to support their nuclear, pollution and claims cooperation committees. And as part of that, I help represent the group at the IMO and IOPC funds. Prior to joining the international group, I also worked for one of the 12 P&I clubs that form the international group, where I worked in their claims department and then latterly as head of legal. Now, whilst I can see a lot of familiar faces from the P&I world in this audience, I am conscious that there are also those who will be less familiar with the international group. So I thought I'd begin by just giving a brief overview of who we are, what we do, and then look in more detail at where we are in our journey when it comes to nuclear energy solutions for commercial vessels. The International Group of P&I Clubs is an unincorporated association of 12 mutual P&I insurance companies, and they provide third-party liability cover relating to the use and operation of ships. Between the 12 clubs, they insure approximately 90% of the world's ocean-going tonnage. Now, by grouping together, the group clubs are able to coordinate the pooling of liabilities that exceed an individual club's retention of $10 million up to $100 million. Over this figure, the group obtains a group general excess of loss reinsurance program that enables the group clubs to provide unparalleled cover levels of P&I cover for the benefit of its members. Now, as I'm sure we'll hear from Mark later, this is quite an interesting structure as it has a lot of parallels with nuclear pools, which collectively share risk for the benefit of industry and society in general. The club covers a wide range of liabilities, including loss of life and personal injury, cargo loss and damage, pollution by oil and other hazardous substances, wreck removal, collision, and property damage. However, at present, liabilities caused by or arising from nuclear fuels, nuclear waste, or the combustion of nuclear fuels are excluded from poolable cover between the group clubs. At this point, you might wonder why on earth I am on this panel. Now, despite this exclusion, the group clubs recognise that the shipping industry needs to reduce its greenhouse gas emissions, and nuclear presents a possible solution. As a result of this and the growing interest in nuclear-fueled commercial vessels, driven in part by the advancements in technology, the international group has recently formed a nuclear committee. That committee is still in its infancy, but its primary objective will be to determine whether liabilities relating to the use of nuclear fuels could or should become poolable in the future. Now, the primary focus of this committee for the foreseeable future will be to conduct a scoping exercise, which will explore the full range of steps that need to be taken in order for these liabilities to become poolable. Now, whilst we anticipate that this will require consideration of a number of factors, a crucial element as liability insurers is the lack of a current international liability framework. Absent such framework, in particular the crucial right of limitation, the cost of insurance and reinsurance may prove prohibitive. Now, the international group has long held consultative status at the IMO, and over the years has played an instrumental role in the development and implementation of a suite of liability and compensation conventions. These provide a predictable framework for claimants based on a number of key principles, which Ian helpfully mentioned earlier in the context of nuclear conventions. These include crucial principles like compulsory insurance, that the ship owner, in the context of shipping, has a strict liability, much like an operator, and in return, that ship owner is entitled to limit their liability. This tried and tested framework ensures swift compensation for victims and much needed certainty for ship owners and the insurance that is needed for them to work. The international group hopes to utilise this experience to work with intergovernmental bodies, industry and states to develop an appropriate liability framework. As highlighted in Ian's presentation, a convention solution will take a long time, and we recognise that a bilateral agreement might provide an appropriate framework in the meantime. As part of this process, and recognising that the group clubs currently exclude these liabilities, the International Group's Nuclear Committee is keen to engage with industry parties and understand the potential damages that might arise from incidents involving nuclear-powered commercial vessels, and particularly how these would differ from traditional marine risks. We're therefore very grateful to Core Power for arranging this summit, which we hope will provide one of many opportunities to learn from each other and to open up new opportunities to work collaboratively towards a harmonised liability framework. Thank you.
Wonderful. Thank you, Daisy. It's wonderful to see, actually, a large and important group like yours moving away from the attitude of we can't do it because we haven't done it before, to actually this is something that's important and we need to get ready to do this tomorrow. So I think that's wonderful. I applaud you for doing all that great work. Kimberly.
Good morning, everyone. It's a pleasure to be here with all of you today. It's not very often that I speak to audiences where I don't know about 90% of you. As I was leaving the hotel this morning, I made the fatal error of forgetting my business cards. And for the first time, I felt like I actually had to run back to the room and grab them because I don't know most of you. So because of that, I think it's important to give a little bit of information about why I'm sitting here. What is the role of the Nuclear Energy Agency and why is it important in the liability and insurance sphere? So as Ian helpfully mentioned, there are two nuclear liability regimes. He was mentioning them as the Paris and Vienna regimes, but we look at them as the regimes under the auspices of the OECD and under the IAEA. And so as myself representing the Nuclear Energy Agency, I represent, as one of the many hats that I wear in my role as the head of the Division of Nuclear Law, I'm providing secretariat services to the contracting parties to the Paris Convention, the first convention in the field of nuclear liability. Now, the Paris Convention is a mainly European convention opened by right to members of the OECD, but it could be open to other members or other countries in the world by agreement of the OECD member countries, but that has not yet happened. Because of our role as secretariat to the Paris Convention contracting parties, we work on very detailed issues of nuclear liability on a daily basis, looking at the implementation and the looking at different ways of potentially modifying or even ways of interpreting the convention, particularly in light of the new technologies that we're seeing here, not just in shipping, but as well in SMRs and FNPPs. Now, just as important, however, as my role as secretariat to the Paris Convention, I also am secretariat to our Nuclear Law Committee. And in our nuclear law committee, we bring together heads of nuclear regulatory bodies, the legal departments, and the heads of legal departments at the ministries with competence over nuclear affairs. We have an amazing convening authority for those governments that represent not just the Paris Convention, but also the Vienna Conventions and the Convention on Supplementary Compensation, and as well those countries that are not yet party to any nuclear liability regime. We have a central importance in this area, in our ability to bring those parties together, because at the end of the day, it's going to be governments that need to be the ones working together to effectuate either bilateral, trilateral agreements, or ultimately the end goal, the place that we all hope to be, a global nuclear liability regime for all countries in the world dealing with this matter. And so I think it's really important to mention this, again, because I think most likely looking around the room and having some chats with folks, most of the people here are in the private sector, and there's an incredible amount of enthusiasm, and I applaud that, because obviously this is talking about civil nuclear shipping, but we are going to have to bring those governmental bodies together. And the Nuclear Law Committee has been doing this for decades. In fact, going back to 1957, when it wasn't even the Nuclear Law Committee, it was the group of governmental experts on nuclear third-party liability, which established itself even before the establishment of the Nuclear Energy Agency itself. So we have decades of experience of convening key high-level government representatives who are experts in the field of nuclear liability. And civil nuclear maritime applications is not new to this group. In fact, in 1972, the group developed a model for agreements on visits of nuclear ships. So this isn't something that's new to us. As Ian briefly mentioned, there have been numerous agreements that were already entered into related to port visits for the ship Savannah and the Otto Hahn. The model bilateral agreement is publicly available for everyone. It was agreed to by the Nuclear Law Committee, noted by the Steering Committee for Nuclear Energy. So there are models out there. I wouldn't suggest that you pick them up, just dust them off a little bit and sign on to them. They need to be modernized. They need to be brought into the 21st century. But this is not something that we've never done before. We're more in a phase of, instead of starting from scratch, we're saying what's old is new again. We're learning from the past to prepare for the future. We're trying to figure out what we can do to learn those lessons and bring it forward. So no, I don't think we're in a place of sheer pessimism. Maybe we overly sold the pessimism earlier simply because it's not easy. It is complicated. It's going to require bringing together different worlds. In the nuclear fields, certainly where I am, trying to bring together lawyers, technical experts, and policymakers is as much of a challenging bridge as any, but now you try to bridge those between the entire nuclear sector and the civil maritime sector, and there's going to be a lot of lessons that we need to learn from each other. But there's going to be good cooperation, and events like this are able to have those small steps forward in that cooperation. I'm hopeful that I'll see some of you in this audience at the workshop that Ian mentioned that we're having at the end of the year, literally called Bridging Law and Technology, trying to show those needs for cooperation, where we will have a special session looking at maritime applications of nuclear activities, looking at propulsion, offshore and onshore power. So again, invitation is open to all of you to come to that. But again, we're going to have to cooperate. Governments are going to have to cooperate together. We're going to have to work hand in hand with our colleagues in the insurance community in order to make this work. It's not something that any one of us can pull everyone else in the same direction. And as I dare say, you are going to have to work with folks like us, with the nuclear lawyers like Ian and myself, but I promise we're good folks to work with, and I look forward to all of that, so thank you.
Wonderful. Thank you, Kimberly. And, wonderful to be part of the ministerial at the OECD in Paris in August and September of last year, and just making interventions about maritime nuclear. And I think for the first time, many of the ministers that were there were hearing about this and actually seeing those eyes wide open going, really? This, okay, we're in. So we're really looking forward to engaging with you on these things. And just to paraphrase a great leader, we don't do nuclear for maritime because it's easy. We do nuclear for maritime because it's hard and it matters. So thank you for your support. Mark.
Thanks, Mikhail. And thank you to Core Power as well for inviting me to the summit. A bit like Kimberly, I'm looking out across this room and there are very few faces that I recognise, but I'm sure in the years to come we will all get to know each other a lot better. The good news is, as you've already heard, we have done this before, and we did it in the 1950s. So when the nuclear industry was first forming, and if I can just use the UK as the example, when Calder Hall up at Sellafield was first being commissioned, the government, the industry and the insurers got together. And the first thing that the insurers said to the government and the industry was that this is a very complex risk and it's not something that we feel comfortable insuring. What transpired was the development of a nuclear exclusion. And so in all of the insurance policies, when you go home this evening, dig out your motor insurance policy or your property insurance policy and look at the exclusions at the back, and you'll see that there's a nuclear exclusion. And the reason for that is it's this channeling principle. So by having that nuclear exclusion in all of our domestic policies, it allows the insurance market to channel the capacity into vehicles like mine. So back in 1956, the British Insurance Atomic Energy Committee was formed. And I like Venn diagrams as well, Ian, because that was very much about the insurance industry, the government, and this newly forming nuclear sector coming together to write risk. Now, today we have nuclear pools around the world. There are 26 nuclear pools. We all support each other, so very similarly to the P&I Club way of working. We all gather our capacity on a net basis because you cannot buy reinsurance. Treaty and facultative reinsurance is not possible in the nuclear industry because of the nuclear exclusions that exist. And so we all collaborate with each other to gather the capacity that's necessary to insure some of these large risks that exist around the world. We provide only insurance that the commercial insurance market cannot provide. So, for example, if a nuclear company wants to buy motor insurance or employees liability insurance, that's insured in the commercial market. We only provide the nuclear liability. We cover the property, so the hot zone and the cold zone, and we also provide the transit liability. And actually, I think there's some good lessons that we can learn from transit liability, because nuclear operators have been shipping fuel and spent fuel around the world on ships for many, many years, and those are covered under the conventions, and we provide the insurance for that transit liability. So I'm sure we can also look at that. So yes, I agree with Ian and everyone else on this panel that the insurance industry can respond to this. Of course, we're going to need to understand the risks. In order to write this risk, we need to understand it precisely. But I'm optimistic that we can develop solutions together with the P&I clubs and together with the industry to help your industry go forward. So you've heard a couple of 1950s mentioned. So maybe in years to come, 70 years from now, there'll be a bunch of people sitting in the room talking, and they'll be referring back to the 2020s when all of this came to pass.
And they'll be referring to us as their forefathers or something like that, right?
Yeah.
Okay. Oh, excellent. Well, thank you, Mark. That's fantastic to hear. And I think it fits beautifully into the framework of what we're discussing today. And I'm just going to preempt a couple of things here with regards to some questions that are going to come out of the audience. One of the knowing people from the shipping industry, we're going to focus on money, right? So when Ian showed us that $500 million in 1953 is equivalent to $5.16 billion today. We have to remember that if you contextualize that cost, that was a few years after the first atomic explosion over a civilian city. It's a tragic event ever. And we had a first of a kind insurance on a first of a kind vessel. Prototypes always cost money. I have no idea what it cost to insure the first motor car that rolled on British roads or the first aircraft that flew, but that insurance cost has come down substantially, and you've probably seen that as well. So it's important for us to think about this concept of channeling. All these exclusion that exists elsewhere should channel capacity into nuclear shipping if the conditions exist for you to do so. So this bilateral arrangements, trilateral arrangements, multilateral arrangement eventually could become a convention that would then channel serious capacity into a large fleet here. And I think that's really where we're focused on this. So thank you all for helping us point this out. I'm going to start with one question before we open it up to the audience, and that's really this difference between a multilateral convention and a bilateral treaty or bilateral agreement. I mean, what effectively, and I'll start with you, and what is effectively is the legal standing of a bilateral versus a multilateral arrangement treaty?
So the good news for us is that they're both legally binding under international law. I think it's fair to say that the big global issues, so look at nuclear liability, for example, has tended to be done by multilateral treaty. And that is certainly maybe a knee-jerk to the way we have to approach this. And as I said, I think that's right in the long term, that ultimately we need a multilateral convention that comes under the auspices of an IAEA, for example, if it's going to be sort of more global. And they manage the convention essentially. But as I mentioned in my talk, there are examples of bilateral treaties that exist today. Every single state has a bilateral agreement with the IAEA about safeguards. Mm. That is legally binding. Many states in the nuclear side have agreements, nuclear trade agreements or nuclear cooperation agreements, which are legally binding and provide the legal basis for trade in nuclear materials, transfer of nuclear materials, and those sort of things. So there is, I think, as you mentioned, Mikhail, there's nothing saying that you can't do this by bilateral treaty. Except the fact that maybe some people might say, well, no, this is the sort of thing that we have typically done with multilateral. But we're not disputing that. We're just saying this is a stepping stone to incrementally build to that.
So effectively then, taking Michael Parker's point from earlier on about the Clydebank Declaration and the creation of potential green corridors between countries for environmental reasons, if you then down-select into a certain subset of those where you would want nuclear-powered ships to function between states that are able to enter into these bilateral arrangements, you potentially then have the sort of marrying together of nuclear liability, marine liability, environmental liability, social justice, all sorts of things that come into this. And that's effectively where that would work.
Absolutely, yeah. And when he said the green corridors, I sort of obviously talked about nuclear shipping corridors from my perspective. And yeah, absolutely.
Good. Kimberly, multilateral treaty, that's your DNA, right? So how do you see that legal standing between bilateral and multilateral in this case?
I mean, obviously, I agree with what Ian said. They're legally enforceable agreements. However, those bilateral or trilateral agreements should not be the end goal. The end goal should be a comprehensive multilateral agreement that provides proper protection to parties that are not necessarily party to the agreement, because if you have an agreement just between the US and the UK, there are potential for issues for countries that are not party to that agreement that might not be covered by that. Obviously, the countries that enter into that agreement are going to be primarily concerned with their own countries and protecting their own interests. And as we all know, in the nuclear field and why we do have these multilateral agreements, nuclear accidents occur and they don't just necessarily occur within the geographic borders of a country. So we need to be concerned about the potential effects beyond the countries that are parties to those treaties. So I think we absolutely should look at that as a stepping stone. If you, as mentioned by Ian, took 18 years for the 2004 protocols to the Paris Convention to ultimately enter into force. That's from the time that the agreement was made. If you look at when the parties started talking about it, you're getting into 30 years. So these things take time. That being said, as much as bilateral agreements certainly are faster, and I'll never dispute that. There are the potential for hangups. If you look at some of the 1, 2, 3 agreements and nuclear cooperation agreements in the United States, there are some that are still taking years and years and years because of certain requirements and the governments in that. So again, there are always sticking points that can be made, but I do think it provides a good framework for starting, and there's nothing that says it shouldn't start there. But don't end there.
I think Ian made points. If you're trying to do everything everywhere all at once, I mean, you're setting yourself up for a multi-decade thing. And I think one thing we've learned is that by setting out a logical sort of step-by-step approach with the right dependencies in it, you create the pathway to get to that point. And I think you're absolutely right. We need to get to that.
And I would just also mention that I hope that when and if countries do start negotiating these agreements, that they do work with their international organization counterparts, whether it's myself at the NEA or with my fellow colleagues at the IAEA, because if ultimately a multilateral agreement is something that is desired, you do want to start at least having some of those political and diplomatic discussions early, so countries don't feel like it's been led and powered by certain countries, and that if they don't jump on the bandwagon, they're going to get sort of beat up for it. So you want to make sure that you do start those diplomatic entreaties early, because this is ultimately a diplomatic issue.
And please include us as well. One of the slides that Ian gave with the principles of the conventions, even with a bilateral agreement, I think those principles are really key, and it would really help insurers as well to provide capacity, because then we know there's a channeling to the license holder. We know that the court where the flag state is going to handle the claims for compensation.
Very good. Now, I'm looking at the clock, and we have a little bit of time left. I'd love to hear Daisy's point on this as well. But Daisy, if you don't mind, let's open it up to the audience to ask some questions if they have any as well. And if we do run out of time, please excuse us and then come and find us afterwards to ask those questions. Right, can we put the lights up a little bit so we can see the hands? Got one right down here.
Thank you very much. Trudy Harrison, I was the minister at COP26 who stood on the stage and launched the Clydebank Declaration. I was responsible for the transport decarbonisation plan with my good friend Charlotte. So it's disappointing to learn that actually it's made little progress. Back then in 2021, we were talking about creating a green shipping corridor or a nuclear corridor between UK and US, UK and France, UK and Japan, wherever it might be. I think it's an uphill struggle in Whitehall. The nuclear scepticism is pretty off the scale, or was. Had Tim Gregory's book, Going Nuclear, been available, then I would have made it essential reading for all of my civil servants. If you could write the speech now, I think we're up to COP31 in Brazil. What would it need to say to make progress on this? And for all of us here who I think really want to make this happen, we're super enthusiastic and excited. And I'm certainly racking my brain now. What can I be doing to make it happen? What are our jobs for the weekend, jobs for the next few months to support you in this mission?
I'd love to answer that question, Trudy. Thank you. I mean, if we're going to write that speech now, and a 20-second elevator version of that speech would have to be that we have been taught to be afraid, and we have been taught well. We've got to revisit what it is that we have been taught and why. And let's follow the money to try and figure out why we were so convinced that nuclear was such a bad thing. And if we do that, we will emerge out on the other side, and we will find that the disastrous accidents that have happened have been little more than fender benders, but the audience around us run and scream away in fear because they've been taught so well. So let's re-look at this, and let's look at it in the clear light of day, in a logical manner, and see what benefits we can get from nuclear rather than how it can feed those fears that are pervasive in society. And I think if we get the opportunity to do that through politicians, through civic society engagement, through dealing with local populations in areas that are going to be touch plates for ships coming into ports and floating nuclear power plants on coasts, etc., I think we will succeed in doing so. But it's a re-education of our own attitude towards the future of our lives, future generations, and the environment.
Hello, I'm Jimena Vázquez-Meño. I'm counsel at White & Case. Thanks for the panel. I mean, nuclear liability is a super exciting theme, right? And I must say that I agree with Kimberly with regards to the approach that it's needed. I mean, with regards to the international liability conventions that we've had until now, we have lessons learned. And so from the lessons learned is that we have a patchwork of conventions, and that's what can happen if you do bilateral agreements. Countries will want to have their own approach, let's say. So it's going to be difficult in the future afterwards to have them change their mind and also to harmonize. So that's going to be a problem. We see also the challenges that we have with regard to insurance because of the different regimes, the different amounts. And so that foresees some problems. And also, even if you have a bilateral agreement between, for example, the US and the UK, you can always have an accident where a third party can have nuclear damage or also an accident on high seas. And that will not be covered because a bilateral agreement only engages the two countries. And so you will be in the same situation as Ian mentioned after Fukushima, because there's not going to be treaty link between the victim and the ship that caused the damage. And also, finally, because, well, it's a long list, but the thing is that nuclear liability conventions, one of the issues why they exist, it was in order to share risks with the industry. And here, in fact, and the problem, and as you can see, and the provision, the indemnity provision that Ian showed, I mean, that's one you have in almost all contracts with regard for suppliers. And because you're going to have the suppliers, you're going to have the investors, and you're going to have the banks, if they're not from the countries that have signed a bilateral agreement, will be at risk of being sued potentially. So that's why, I mean, I know that it has, I mean, Paris Convention, 17 years for the protocol to went into force for many reasons. One of them, insurance. But the thing is that when there is a will, there is a way. After Chernobyl, some international conventions were adopted pretty quickly. So if I know that we really need these nuclear ships right now, so countries may potentially put in the effort to try to come up with an international convention.
Thank you, Jimena, for that. And on that sobering note, thank you for bringing us down to earth. I'm going to thank our panelists for participating. Thank you very much for participating with this, and to you for listening, and pass it back to Charlotte. Thank you.